Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode, episode 32, we're going to look at a recent IRS private letter ruling which examined the mergers of trust and the effect of a merger on the IRA trust look-through rules. Now, I could take up much more than a tenth of an hour talking about the principles of IRA trusts and the look-through rules themselves, so I'm just going to give a quick 30-second background. When you have a beneficiary of an IRA, the IRS will allow you to stretch IRA distributions. At least before the Secure Act they did this. They allowed you to stretch IRA distributions over the life of that beneficiary so long as the beneficiary was an individual. However, for beneficiaries who were not individuals, such as trusts and estates and charities, the default rule was that the IRA had to be paid out in full within 5 years of the owner's death. But within the Treasury regulations, there's some rules that apply that allow you to name a trust as an IRA beneficiary and get that lifetime stretch for the life of one or more individual trust beneficiaries instead of being stuck with that 5-year payout rule, which could also be a 10-year payout rule sometimes, depending on some changes on the Secure Act. But four requirements that have to be met is that the trust has to be valid under state law. The trust is or will become irrevocable upon the death of the IRA owner. Most importantly, you can identify the beneficiary with the shortest life expectancy under the trust. And one caveat to that that really fits into the regs is that there cannot be any entity like a trust or an estate or a charity that can benefit currently if the trust is a conduit trust, or ever benefit if the trust is an accumulation trust. Then finally, by October 31 of the year following the year of death of the IRA owner, you have to provide relevant information such as the trust agreement to the IRA custodian. Now, that's all simple and pretty established when it comes to a regular trust. But what happens if a look-through trust ends up being merged with another trust? That was the question answered in Private Letter Ruling 2020-35010. And in this case, there was a merger of trusts. The initial trust did qualify as a look-through trust, but it was going to be merged into a larger surviving trust pursuant to a merger agreement. And in this case, the IRS allowed the merger and determined that the surviving trust would indeed also qualify as a look-through trust. The key point here was that in addition to the two trusts agreements, the IRS also read the merger agreement and determined that its effects on the surviving trust would cause there to be a look-through trust, because importantly what the merger agreement provided is that the rights of the beneficiaries to the IRA into the target trust could not be altered under the new trust. Now, the surviving trust, the new trust, did have language that could have allowed the alteration of the beneficiary's interests, but the merger agreement cut off those provisions. And most importantly, what kind of flew under the radar as well is that the merger agreement became part of the trust information that had to be disclosed to the IRA custodian by October 31 of the year following the year of death of the IRA owner. Now, a lot of that just seems procedural, but there are some key takeaways to keep in mind here. One, like I just said, the merger agreement has to be provided in addition to the trust documents to the IRA custodian by that October 31 deadline. I think it's also important to note under state law, the provisions of the trusts and the merger agreement and how those all come together, and note whether the merger agreement could indeed alter or limit the terms of a trust under applicable law. It could here, but that might not always be the case depending on which state the trust or trusts are administered in. And then finally, even though the Secure Act didn't apply in this ruling, I think it's important to emphasize that the trust look-through rules are still important for the exact reasons that I emphasized at the beginning, that you want to avoid that 5-year payout. And I won't really dive into this here, but the importance of the look-through rules now pertains to the classification of individual beneficiaries as well, because you have to be able to identify whether those individual trust beneficiaries are eligible designated beneficiaries or merely designated beneficiaries. And if they're eligible designated beneficiaries, then you can worry about what their age is in determining the eligible designated beneficiary with the shortest life expectancy. Thank you again for joining me for this episode of the 10th of an Hour. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening, and I look forward to seeing you in the next episode.